Good afternoon, everyone. Thanks for joining us for this third seminar in our series looking at Mental Health Act and the deprivation of liberty safeguards. You're very welcome this afternoon. I'll be chairing and speaking first, and I'm Francis Lyons. With me in presenting on some of the more tricky issues that relate to the care and treatment of children is Charlotte Radcliffe, who will be speaking after me. I'm sorry about the technical issues we experienced overnight. Our video provider, Zoom, managed to rot up all of our booked webinar features, so we've had to hastily rebook them. So I'm grateful for you for bearing with us and re-registering for this event. For colleagues that may be delayed getting on or who may not get on at all, we will be recording this webinar, including the Q&As at the end, and we'll be circulating that video recording together with the slides for your reference and if you'd like to share it with colleagues at work. There will be a Q&A session at the end, and through the Zoom platform, there will be a Q&A box. If you'd like to put your questions in there, then we'll deal with as many of those as we can at the end of the webinar. And if someone's asked a question that you think is really good, please like that question, as it will push it up the rankings, and the ones that are liked the most will appear at the top of the list, and we'll work through them in that order. If you've got any difficulties with the sound or with the vision or anything else along those lines, please do feel free to put those comments or queries into the chat box, and our administrative support will tackle those and endeavour to help you as soon as they can. And lastly, on the administrative points, we'll be sending out a feedback form after this event, and I'd be very grateful if you could fill that in to let us know what you thought of today's events, as well as with suggestions for the future. I can see our participants are rising steadily, so those of you who are just joining late, my apologies again for the problems with the technical glitch with the Zoom video platform. We will be sending around a recording for anyone who joins later than this. So without further ado, I'll crack on with the slides. My intention for the first part is to quickly run through a reminder of what the Mental Health Act and the Mental Capacity Act codes say about restraint and deprivation of liberty, before going on to have a look at some of the more recent cases about whether a deprivation of liberty actually arises, and if it does, whether you need to actually seek authorization or not in a clinical setting where someone may be presenting with acute physical needs, as well as with a mental disorder. The one point I really want you to take away from today is that actually restraining someone and depriving someone is perfectly okay. The key issue is to identify whether it's a restraint or a deprivation of liberty, and if it is a deprivation of liberty, to make sure you get an appropriate authorization for it, because the courts readily recognize that deprivations of liberty are necessary, but what they're worried about is when there's no oversight or review of that. And that's a consistent theme through the courts and through the Mental Capacity Act and through the Mental Health Act. If you have a deprivation of liberty, you must get it authorised. So the starting point for today's webinar is the Mental Capacity Act code, which acknowledges that staff under common law can take appropriate and necessary action to restrain someone in order to prevent harm to that person and to anyone else. Common law is simply common sense, which the judges have approved. But the code goes on to say common law of itself doesn't provide sufficient grounds for an action that would deprive someone of their liberty. So you can restrain someone in the moment in an emergency in order to keep them safe or to keep others safe. But if that's going to last for any significant period of time, then you need to get your authorization from the deprivation of liberty from somewhere else. And here we see at paragraph 6.50, the code again recognizes that you may have no choice in some circumstances other than to deprive a person of their liberty. And moving on, that in some circumstances, it may be appropriate to detain somebody under the Mental Health Act. And during the course of today, we'll look at the circumstances when you may have no choice other than to detain someone under the Mental Health Act, or when you may have a choice between the Mental Health Act and the deprivation of liberty safeguards in order to get authorization. But importantly, again, you must get an authorization if there is a deprivation of liberty, whether it's under the Mental Capacity Act or under the Mental Health Act. Now, Just below the level of deprivation of liberty, we've obviously got the ability to restrain patients and impose a restriction on their liberty. That will be for a shorter period than a deprivation of liberty, but if restraint continues for any length of time, then it may amount to a deprivation because it's gone on too long. But you don't need an authorization to restrain someone. There won't be an offence by you, and it is lawful to do it if you believe it's necessary to restrain the person in order to prevent harm to the patient, and that restraint is proportionate to the likelihood of the harm that's going to be suffered and the seriousness of that harm. So if there's a 1,000,000 chance that someone's going to stub their toe, then clearly restraint probably isn't going to be proportionate. But if there's a 1 in 10 chance that someone's going to get hit by a bus if you don't restrain them, then clearly that's going to be permissible. Threats of the use of restraint also amount to restraint, and any attempts to prevent someone from leaving or to restrict their liberty also amount to restraint. So you might not have hands on them, but if you've locked the door to prevent them leaving the room, then that is also a restraint. And then rather unhelpfully, the code essentially says that you do more than restrain a patient if you deprive them of their liberty without actually fleshing it out with any more examples. And to provide further reassurance to you then, the sections we've just been looking at have been the Mental Capacity Act code. What the Mental Health Act says is largely the same. So sections 5 and 6 of the Mental Capacity Act can't be relied on in order to enable a deprivation of liberty. So if it goes further than simple restraints, you've got to get authorization from somewhere else. And the Mental Health Act code acknowledges that that's either through the Mental Capacity Act by a deprivation of liberty safeguard authorization, or a court order, or lastly, through the use of the Mental Health Act. Looking forward slightly, the liberty protection safeguards, which now aren't going to be coming out until 2022 in the spring at the earliest, they extend the provisions to when you can deprive someone of their liberty in an emergency. And at the current time, you can still deprive someone of their liberty in order to give life-sustaining treatment or do a vital act. And a vital act is anything that prevents a serious deterioration. So that remains the same, provided that the steps are necessary to give life-sustaining treatment or do the vital act. What that means, skipping through the legalese, is you can only restrain somebody and deprive them of their liberty if it's necessary to deprive them of their liberty in order to carry out the clinical acts that you need to give them. If in fact you can just restrain someone temporarily, give the treatment, and then they're free to go, then that will only be restraint and you don't need a separate authorization in order to do it. You've necessarily got to believe that the patient lacks the capacity to consent, because otherwise you should be asking them and then complying with their wishes, unless they need compulsory treatment for a mental disorder, in which case you'll be stepping out of the Mental Capacity Act and into the Mental Health Act. And then fourthly here, this is where we start to see the new changes that will come into force but aren't in force yet. So A and B is the current position. So you can take all those steps 1 to 3 if there's an emergency, or if there's an application to the court already in process in order to get an authorization for deprivation of liberty. But under the new LPS, it will also be sufficient for you to have set in train an application to a responsible body for an authorization under the LPS, which is largely the equivalent of getting an application into the local authority now, if you're trying to get your head around what that means. And an emergency situation arises in these circumstances. So where there's an urgent need to deprive the patient of liberty in order to give the life-sustaining treatment, and it's not reasonably practicable to await either an application under the Mental Health Act, an application to the court for a deprivation of liberty under the Mental Capacity Act to be determined, or for an authorization under the Liberty Protection Scheme to be granted. And those sections which I've underlined aren't currently in force, but will be when the LPS come in. So you've got a one-stop shop there of the provisions as they arise. I then wanted to say just a few words about what those of you who are familiar with this area of law will know as the acid test. That's based on the Cheshire West case, but it also reaches further back to case law from Europe. And it's important because that then raises the issue as to who's actually responsible for the deprivation of liberty. And what the European case law says is, first of all, there's got to actually be a confinement for a non-negligible length of time. So is there a deprivation of liberty? Is there anybody who can consent to that deprivation of liberty, be it the patient perhaps with capacity or someone else with lawful authority to consent on their behalf, which may be a child in some circumstances, which Charlotte will come on to talk about in a few minutes' time. And then lastly, is the deprivation of liberty attributable to the state? And if it's not attributable to the state, then you as a health and social care professional may not actually need to apply. And we'll look at some case law along that further. You'll all be familiar, I think, with the Supreme Court's iteration of this test, which is more simple, which is that is the person subject to continuous supervision and control, and are they free to leave? And that's the test that you should go to each and every time. But there's been case law on this, which makes the position a bit more complex for those of you operating in the acute hospital setting trying to deliver physical health treatment. The Ferreira case is an important one. The facts in brief are that the lady suffered from a learning disability and for all intents and purposes couldn't consent to the treatment that she needed in hospital. She had a number of physical health complications requiring her admission to hospital, and whilst in there, she extubated and sadly died. There were coroner's proceedings within which the coroner ruled that the patient was not deprived of her liberty, requiring the hospital to have applied for a DOLS authorization during her stay in hospital. And that was subsequently appealed to the civil courts. And it's that bit that's interesting for our purposes, because the court said that any deprivation of liberty resulting from the administration of life-saving treatment to a person falls outside the scope of Article 5.1. So essentially, if you're depriving someone of their liberty in order to give someone life-sustaining treatment to prevent real risk of serious injury or damage, then you don't have to worry about the deprivation of liberty safeguards. The judge went on to say his conclusion removes what would otherwise be the absurd consequence of the absence of any lawful basis under Article 5 for depriving individuals of sound mind of their liberty for the purposes of administering life-saving treatment. In other words, what he's saying is if someone's dying in front of your eyes, you don't have to worry about getting a DOLS authorization because you're not depriving them of their liberty in order to provide the treatment. They're there because they can't leave and they need to be saved by you. And importantly, the subsequent cases have developed what the judges went on to say about urgent medical care, because the preceding slide was just about life-sustaining treatment. But the judges went on to say there is in general no need in the case of physical illness for a person of unsound mind to have the benefit of safeguards against the deprivation of liberty where the treatment is given in good faith and is materially the same treatment as would be given to a person of sound mind with the same physical illness. Treatment is neither arbitrary nor the consequence of their impairment. So what the courts are trying to ward against there is putting in place extra bureaucracy for patients who aren't able to leave because they're really, really ill, but may also have a mental disorder, but the presence of that mental disorder is frankly irrelevant to the care regime which they've got. So if you've got a learning disabled patient in bed A, doesn't in normal times have the capacity to make a decision about open heart surgery, but then you've got a cognitively able person in the next door bed who also requires open heart surgery. Both of them are likely to be unaware of where they are when they come around from surgery. They're going to be disoriented, they're going to be sedated to help with the pain, and they're not going to be free to leave because of the surgery that they've had. But when the patient in bed B, who's cognitively able, starts to recover, then the restrictions will lessen. But the person in bed A who's learning disabled and may not be able to make decisions about where they live to receive care and treatment may then start to have restrictions and a deprivation of liberty imposed on them, not because of the surgery, but because of their underlying mental disorder. And it's at that point, but not before, that as treating professionals, you need to have to think about putting in place a deprivation of liberty, because those restrictions are a product of a mental disorder, not the treatment that's needed for the physical issues from which the patient is suffering. The last case that I wanted to touch on before handing over to Charlotte raises the issue of when continuous control and supervision arises, because the judge has now changed the test slightly to get us to think about not only freedom to leave, but also continuous control and continuous supervision. And it's not sufficient now for someone to be within continuous observations, for instance, to be subject to the acid test. And in this instance, AB had been sectioned under the Mental Health Act, but was then placed under guardianship, which required her to live at a certain placement. But at that placement, she was free to come and go as she wanted. There were staff always on hand, but she didn't have to accept their support and she could leave. She was in supported living because she found it very hard to look after her own needs. Staff would also wait for her to leave the premises in order to go in and tidy up, because otherwise the place would very quickly become uninhabitable. And it was significant in the judge's view that the staff were able to go in whenever they thought fit. Now, they wouldn't go in when she was there, they'd wait for her to go out in order to go in. So they were constantly aware of her comings and goings. So it wasn't an issue that she wasn't free to leave, because the guardianship order required her to live there. So there was no question of her being able to choose to live somewhere else. But the question was she subject to continuous supervision and control? Because she could come and go as she wanted, unescorted. And the judge said that supervision and control should be viewed as separate requirements. So you have to consider whether she's subject to continuous supervision, and then separately consider whether she was subject to continuous control. And the judge went on to say that while she's free to leave the property, she is always subject to state control, because it was a state-funded placement, requiring that she return should she otherwise be unwilling to do so. The fact that she does come back is irrelevant, because if she didn't, her whereabouts were always known, and someone else would largely go out and find her. And the court went on to say that the power to enter someone else's private residence is a major intrusion, as it is here, and it's to her benefit that it should happen. But overall, looking at this in the round, although she wasn't subject to continuous supervision, she was subject to continuous control, because if she didn't return, she would be brought back. And the judge then found that there was a deprivation of liberty and authorised it. And it's worth bearing that in mind, because if you've got patients on a ward who aren't being constantly watched and aren't locked in, but if they do make an effort to leave, would be brought back, then that probably triggers a deprivation of liberty authorisation. And finally, I wanted to just touch on the S.136 case, which deals with a long-stay patient in hospital who had a complex medical history, which I won't say a great deal about, but it's on the screen. She was in and out of intensive care and was generally believed to have lacked capacity. It was planned initially for her to be discharged home with a CHC-funded package of care in order to look after her, but there were concerns about that discharge because she had a tracheostomy tube in. And the patient got it into her head that she couldn't go home whilst intubated, doing a sort of shortcut as to the reasons why her discharge had been delayed, despite the fact that her family and she wanted to go home. As part of the planning process, it was only in April, noting that she'd been admitted in January, that a psychiatrist found that she didn't have the capacity whether or not to decide to have an angiogram, but had warned in February that she really needed to have a capacity assessment generally to work out whether she had the whether she had the capacity to make decisions about where she lives and what treatment that she has. In May, then finally, there was an assessment of the capacity to decide where to live. So this is 5 months after her admission. And it was decided that she didn't have capacity. She was discharged to a nursing home in June, and she sadly died just a little over a week later as she pulled out her tracheostomy tube. What then happened, unfortunately, was a legal challenge where the family sued for clinical negligence and brought a challenge under the Human Rights Act. And there was some finger pointing between the trust and the care home as to who was to blame for the patient being able to extubate whilst in the home. And the judge concluded that the care home's failures were due to the trust not giving the care home enough information about the risks that the patient posed. And in the sad judgment, the judge concluded that the patient had tried to extubate because she saw that as the best way of getting home, but she knew she couldn't go home while she was still intubated. The judge went on to say that despite the clear recommendations made by the psychiatric team within the trust that mental capacity assessments should be carried out, they weren't done in good time, and actually the process for sorting out the disputes with the family about where she was best placed seemed to have been specifically overridden by the trust. From early February, she'd been saying she wanted to go home, but until discharge, well, up until the point of discharge, there was no proper capacity assessment or best interests meeting. And the court went on to say what should have happened, because it was clear there was a dispute about where she should live, is that the matter should have been referred to the Court of Protection. And in a particularly damning paragraph, the failure to get the authorization, the judge said, showed an appalling disregard for the patient and her family. He said that she'd basically been unlawfully imprisoned for 120 days because of the failure to get the authorization. The family asked for £30,000 in damages and actually awarded a run rate of £130 per day, and then awarded an extra £5,000 for aggravated damages, just because, in his view, the trust had not behaved as it should have done, and as we've seen above, described it as appalling behaviour. Now, the reason I bring this case to your attention, even though it's relatively old, is the importance of getting the authorization. There wasn't much dispute that she needed the care and attention that she got. There were arguments about the location of where that should be delivered, but there was no question that she needed constant supervision and control. The failing of the organization was not to apply for the authorization when she needed it. And as you can see from that, there are significant sanctions will be brought, and bad PR, of course, if those authorizations aren't put in place. On that note, I'm going to hand over to Charlotte to deal with some of the tricky issues in relation to children.
Hello all. As Francis has said, I'm going to be talking about the practical issues regarding the treatment of children. In particular, I'm going to be covering the following topics, which looks like a lot for a 12-minute talk, but we will get through all of them. So first is parental responsibility, best interests, consent, some tricky issues regarding 16 to 17-year-olds in particular, the overlap between patients with capacity and the added issue of parental responsibility, the Mental Health Act, hospital admissions and general issues to consider, deprivations of liberty for 16 to 17-year-olds in particular. Francis has obviously covered DOL in a much wider context. The Mental Health Act informal admissions, as well as formal admissions, scope of parental control, and then lastly, the protection for healthcare professionals under the Mental Capacity Act. So ending on a positive note. Francis, if you wouldn't mind clicking over, great, thank you. So the first topic is parental responsibility. Who has parental responsibility? In short, child's mother, unless that's been revoked. So if the local authority are involved or there's a care order, then do consider that if there are safeguarding issues regarding the mother. Child's father, under certain conditions, if married at the child's birth or registered as the child's father only after the 1st of December 2003. Or the court has awarded them parental responsibility if not otherwise. A guardian if the parents are deceased, the local authority if there's a care order in place, a person who has a residence order, or the local authority or authorised person who holds an emergency protection order. So it's a fairly long list, and you'll rarely come across all of them, but they do crop up. So moving on to best interests. The Royal College of Paediatrics and Child Health framework says that all members of the child health team, in partnership with the parents, have a duty to act in the best interests of the child. So that's your overarching drive and aim when treating children. Therefore, when treating children, do involve parents and the children in best interest discussions wherever possible, if appropriate to do so. Parental wishes and interests are important, but they are not determinative. So do bear that in mind. It's assessed on a case-by-case basis and the facts of that case. consider also the parents' interest as against the children's interest, as they are not necessarily the same. And quite a lot of the cases we see, in fact, they are not the same. It can be quite difficult, and I'm sure you've all seen before, for parents sometimes to disentangle their own emotions from a child's best interests. And then lastly, do bear in mind that the Mental Capacity Act only applies to 16-year-olds and above. For any child younger than that, we're looking at Fraser or Gillett competency. In terms of consent generally, some general background that you become an adult in law on your 18th birthday and have parental responsibility up until that 18th birthday. Once you hit 16, you're presumed to have capacity. That's when the Mental Capacity Act kicks in. And therefore there's an overlap between 16 to 18 years old, where you're presumed to have capacity, but the parents also have parental responsibility. I'll come on to that in a bit more detail in a couple of slides' time. Under 16-year-olds can be Gillett competent if they have sufficient maturity and intelligence to understand the nature and implications of that treatment. And consent is usually needed from only one person with parental responsibility. So that's quite an important factor that's often overlooked. But if another person with parental responsibility disagrees strongly with the decision and is likely to take action to prevent the intervention, then do seek legal advice, because if there is a strong dispute about, for example, serious medical treatment, it may not be so straightforward, and it's worth considering whether it would be helpful to have or necessary to have a court order in place authorising that treatment. So I mentioned the overlap between 16 to 18-year-olds where the child will be considered or presumed to have capacity, but they are still subject to parental responsibility. So the Family Law Reform Act 1969, so fairly old act, does help clarify the situation. It's a fairly complex situation. It doesn't make it any less complex, but it does set it out clearly. So Section 8 of the Act says that consent of a capacitated minor over the age of 16 to surgery, medical or dental treatment is valid, and it is unnecessary to obtain consent from a parent. Although, do note that the Act then says if someone with parental responsibility can consent on behalf of a capacitated patient under 18 if the patient refuses treatment. But, and I've put this in red, beware of going ahead with treatment despite a capacitated child's refusal. For all sorts of reasons, as are set out in the Mental Capacity Act, Human Rights Act, Mental Health Act, and the Mental Health Act Code of Practice. So that is a slightly sticky situation that it is complex, and if you are uncomfortable with proceeding, then do seek legal advice. If there is a dispute as well, more generally, again, do seek legal advice with regards to a potential court application. Just so that you're aware, there are currently no specific rules for deciding when to use either the Children's Act or the Mental Capacity Act when applying to the High Court, but that's not really something for you to worry about. It's more for us when we actually make the application. And if you were at all curious, at the moment, we generally tend to make the application under both. So Francis, if you would click over to the next slide, that's great, thank you. So in terms of consent and Gillett competence or capacity compared with or overlapping with parental responsibility, the following scenarios essentially arise, and this is a bit of a summary of the outcomes of each. So the first scenario is that the patient or the child has capacity or is Gillett competent and makes a decision to have treatment, in which case parents cannot usually override that decision. The second tricky scenario is that the child has capacity or is Gillett competent and makes a decision to refuse treatment. Then technically the parents can, in theory, override that decision. But as I mentioned before, do beware of going ahead with treatment against a competent child's refusal. The third scenario is a little bit more straightforward, where the child does not have capacity or is not GILIC competent, then the parents with PR or parents with parental responsibility can make decisions on their behalf. I'll touch on here the Mental Health Act Code of Practice, which sets out the relevant legislation under Chapter 19. It mentions the Children's Acts, as I've mentioned, both the 1989 Act and the 2004, the Mental Capacity Act and the Human Rights Act, 1998. Now I've put this in bold because it does say in the Code of Practice that professionals, practitioners and others responsible for the care of children and young people should be familiar with this legislation. Now, I don't think that means that you need to know it inside out and be able to recite it in your sleep, but you ought to be aware that it exists and generally what those pieces of legislation do. Next topic is admissions and general issues and things to consider when a child presents at hospital. If the child is not GILIC competent, then do consider parental responsibility. If that's not appropriate, the court or the Mental Health Act. If the child is GILIC competent, if they consent to admission informally, they can be admitted to hospital. If they do not consent to admission informally, then consider the court, the Mental Health Act for formal admission, but not parental responsibility. And I explain that in a couple of slides' time. The next slide will discuss young people and deprivation of liberty, particularly regarding 16 to 17-year-olds. So if a 16 to 17-year-old lacks capacity, a person with parental responsibility cannot consent to their deprivation of liberty. And that was decided in Reedy in the Supreme Court in 2019. And in that case, it related to a deprivation of liberty for a 16-year-old. The Supreme Court found that, or held that, a parent's right to control their children decreases as they get older. Children who lacked capacity to make their own decisions about care arrangements had a right to protection from being deprived of their liberty without lawful authority, and that a parent could only consent to their child being deprived of their liberty if it was normal for a child of that age. The level of supervision and control that D was subject to in this case was not normal for a child of 16 or 17. At first instance, interestingly, the court held that the parents could not consent for the deprivation of liberty. Just to give you a run through the courts, the case was then appealed to the Court of Appeal, who held that parents could consent to a deprivation of liberty. And then, as I say, the Supreme Court decided ultimately that parents cannot consent. So that is currently the common law. So if there is a deprivation of liberty, do consider either applying to court for authorisation of that deprivation of liberty, as Francis has explained, or consider using the Mental Health Act if that's appropriate. Regarding informal admissions, I've set out here a couple of the paragraphs from the Mental Health Act Code of Practice, which states that the valid consent of a child or young person will be sufficient authority for their admission to hospital and or treatment for a mental disorder. Additional consent by a person with parental responsibility will not be required. It is good practice to involve the child or young person's parents and or others involved in their care in the decision-making process, if the child or young person consents to information about their care and treatment being shared. Now, do note that blanket consent forms aren't acceptable and shouldn't be used according to the Code of Practice, so do bear that in mind. The next slide, again on informal admissions, says that parental consent should not be relied on where the child is competent or the young person has capacity to make the particular decision. In respect of 16 or 17-year-olds who have capacity, parental consent cannot be relied on to override that young person's decision about their admission. It then goes on to say that although in the past the courts have found that a person with parental responsibility can overrule their child's refusal, such decisions were made before the introduction of the HRA, the Human Rights Act, and since then court decisions concerning children and young people have given greater weight to their views. So that's my beware caveat for those earlier scenarios I discussed where a competent child is refusing treatment between the ages of 16 and 18, where a person with parental responsibility agrees to that treatment. So do beware. Section 131 of the Mental Health Act essentially summarises this and covers cases where the patient, the child has capacity. And it relates to the mental health code of practice that I set out on previous slides. Section 131, subsection 3 says that if the patient consents to the making of arrangements, they may be made, carried out and determined on the basis of that consent, even though there are one or more persons who have responsibility for him. And then subsection 4 says that if the patient does not consent, arrangements may not be made, carried out or determined on the basis of the consent of a person who has parental responsibility for him. So do bear in mind that's where the child is considered to be able to make decisions themselves and be competent to make those decisions. The Mental Health Act, section 131A, covers the environment for child patients, and it's just worth flagging this. This relates to patients who are not yet 18, and it requires that the managers of the hospital shall ensure that his environment in the hospital is suitable to having regard to his or her age, subject to their needs. So that essentially means you should not normally accept admissions of young people aged 16 to 17 to an adult ward. And there may, of course, be exceptional circumstances where you can consider that, which are referred to in the Mental Health Act Code of Practice. And those exceptions generally fall into two categories. The first being emergency situations, and the second being atypical cases. But do consider that the section 131A of the Mental Health Act does say that it requires that manager of the hospital must consider suitable arrangements and a suitable environment. So if you are considering an exceptional circumstance, then do consider that carefully. Formal admissions, children and young people can be detained under the Mental Health Act. So that's something that you can certainly consider if necessary and appropriate. Information must be provided to detain patients and should be tailored to the age of the patients, and do consider their right to confidentiality and the preservation of the dignity of children and young people. And just because they are under the age of 18 does not necessarily mean you can discuss absolutely everything with their parents. So do respect their right to confidentiality. I next discuss scope of parental control. This is a relatively new concept which applies to both children under 16 years old who are not GILIC competent and young people aged 16 to 17 years old who lack capacity as per the Mental Capacity Act. To check whether admission or treatment decisions are within scope of parental control, consider, is it a decision you would expect the parent to make? And is the parent acting in the best interests of the child? If yes, then it is within scope. If no, it is outside. A bit more detail about parental control. In particular, is this a decision that a parent should reasonably be expected to make? This goes beyond routine decisions in relation to medical care, and significant factors in determining this question are likely to include the type of invasiveness of the intervention. Is a child or young person resisting the treatment, and or is treatment controversial? For example, are you considering ECT? Also consider the age or maturity and understanding of the child, and the extent to which the decision accords with the wishes of the child, and whether they're resisting the decision or had expressed any views about the proposed intervention when they had competence, if they've had it previously. The next slide, of their child. For example, is there a particularly acrimonious divorce or other family dynamics that are pertinent? And is the mental health of the child, or has the mental health of the child led to significant distress and or conflict between the parents, resulting in an inability for them to decide decisions about the child's treatment? And then my last slide relates to Section 5 of the Mental Capacity Act. So for children 16 years old and above, and it simply states that a healthcare professional who carries out acts in connection with the care or treatment of a young person aged 16 to 17 who lacks capacity to consent, and it is reasonably believed it is in their best interest, has the protection of liability under Section 5 MCA. Now that's in relation to acts that are carried out in relation to the Mental Capacity Act only, but it is a useful section to rely on if you are faced with that situation. So those are my slides complete, and I will now pass back to Francis.
Thanks very much, Charlotte. So in this last session for question and answers, I'm going to look at what powers are actually available to you and when you might like to use them. And this is where we've seen the most change. So it started off being the position that if someone was eligible and could be detained under the Mental Health Act, then they ought to be, and you ought not to use the deprivation of liberty safeguards. And then there was a distinct sea change with the AM case, where the judges ruled that actually there may be patients whom there is a choice. You might be able to use the DOLS, you might be able to use the Mental Health Act. And if it's possible to make a choice between the two, then the deprivation of liberty safeguards is generally to be preferred because it's perceived to be the least restrictive. We've now come to a position which we looked at in more detail in our earlier webinars, where the court is actually quite happy to approve a discharge from a Mental Health Act section onto deprivation of liberty safeguards, perhaps in a specialist care home, where some of the purposes of the deprivation of liberty are to prevent the patient from reoffending, on the basis that the courts just earlier this year have been saying that it is without shadow of a doubt in the best interest of the patient not to reoffend, because it's in their best interests, A, not to commit the offence, and B, not to be prosecuted and charged for those offences. So we're seeing a definite blurring of the lines in relation to when something is quite clearly in the public interest because the patient presents a risk to others, as to when it would traditionally be under the Mental Capacity Act sphere because it's in their best interests, with the courts blurring it to say this principle of stopping someone from offending is actually in their best interests. So it looks like the scope of the Mental Capacity Act is on the march and coming actually more into the territory of what has traditionally been the Mental Health Act sphere of operation. By way of reminder, the Mental Health Act itself is solely concerned with medical treatment for a mental disorder, but, and there's some examples quoted here within the Code of Practice, you can use the Mental Health Act to treat the physical symptoms of a mental disorder. And also, if someone is refusing physical health treatment as a result of their mental disorder, you can also then sometimes consider using Section 63 of the Mental Health Act to treat those physical health symptoms. And again, we looked at that in earlier webinars that we've done. Ordinarily, however, where someone requires physical health treatment and it's not connected to the mental health disorder which they're suffering from, then notwithstanding the fact they're detained under the Mental Health Act, you have to make decisions about their care and treatment under the Mental Capacity Act framework. So first of all, do they have capacity? And if they do and they're refusing the treatment, then you can't treat them. And if they lack capacity, then you have to go on and make decisions in their best interests. And you'll see from the bottom of the slide there that applies equally to children who may be assessed under the Gillett competence framework that Charlotte's just been describing. I've included here a table which I've pinched from the Code of Practice, which is really quite helpful if you're getting in a pickle about what powers you've got at your disposal. And you'll see within the top left-hand corner of the box that I've overlaid the codes table with just a reminder that the references to ACT in this table are references to the Mental Health Act rather than the Mental Capacity Act. So looking at the left-hand column first, if the individual has capacity but objects to treatment for the mental disorder, and they need to have the mental disorder, then only the Mental Health Act is available, because the Mental Capacity Act only applies to those who lack capacity. If the individual has capacity and doesn't object, then the Mental Health Act is at your disposal, but do you need it? Could the patient be admitted informally and have the treatment? And the answer to that will depend on whether or not their capacity is going to fluctuate, or whether or not their compliance is going to fluctuate, because they might say, yes, I'm happy to have it on day 1, but not on day 2. But still, the DOLS and the Mental Capacity Act framework are not available to you simply because the patient objects, because the patient's got capacity. And then moving to the second row, if the patient lacks capacity and also objects, then you can only use the Mental Health Act, because you can only compel somebody to have treatment for a mental disorder using the Mental Health Act. It's the only way it can be done. However, if someone lacks capacity but doesn't object to the treatment, then the Mental Health Act is available, but do you need it? Again, it might be possible to admit them informally and provide the treatment to them that way, but that then raises the question of whether or not they've got the capacity to agree to live where they're required in order to receive that care and treatment. And if they don't, then you'll need a deprivation of liberty authorization to make the requirement for them to live there lawful. And that can either be done through the statutory scheme or through a specific court order, depending on where they're living and depending on whether or not there is a dispute. I then wanted to step back slightly and look at section 136, the new provisions of which have been with us for a couple of years now. So section 136 enables a police officer, and only a police officer, to bring someone to a place of safety or keep someone at a place of safety if they're already in one, if they appear to be suffering from a mental disorder and to be in immediate need of care and control. And lastly, that it's in the interests either of that person or for the protection of others that they be removed to that place of safety. And the wording's been changed slightly now, so that essentially the power can be exercised in a wider range of places than it was previously. So essentially it's now anywhere other than a private dwelling, and it can still be exercised in the private dwelling if one of the people in control of that dwelling invite you in. A place of safety is most frequently a hospital. Now, I've set them all out here, but quite often we get queries about the fact that the police or paramedics or someone else may have brought somebody to A&E when that A&E setting isn't the designated section 136 suite. That doesn't matter under the Mental Health Act. The Mental Health Act doesn't require that it has to be a designated 136 suite. It is far more convenient for everybody concerned if there is a local protocol which does designate where the health-based places of safety are, but any hospital can act as one, and that will be fine, as can the other places designated on the screen, most notably with the change at the bottom there, which is any other suitable place with the consent of the person managing that placement. So if someone's staying with a friend and their roommate's happy for them to be kept there as a place of safety, that's fine. Similarly in hotels or perhaps in a school, if a child needs to be kept in the headmaster's office or somewhere similar, provided there's appropriate consent, then that is fine. The time limit has now shrunk down to 24 hours. So that does present a real challenge, as previously it used to be 72 hours. And of course, the resources aren't in greater abundance than they were when it was a 72-hour time limit. A doctor can extend that time period for up to 12 hours, but only if P's condition means that it's not practicable to assess. And the fact that you might not have enough psychiatrists available to do the assessments is neither here nor there. The reasons for the delay have to be patient-centred, not on the resources. So what do you do if you've got someone who is high as a kite and can't actually be assessed? Well, actually, if someone through their own intoxication isn't able to be assessed, that is a reason to extend. But it does create management problems, because who's actually going to look after that person whilst they're sobering up in a corner? And that's where you may need cooperation from the police and others in order to ensure that proper supervision is provided. The bigger difficulty comes when the time runs out and you haven't either been able to get your assessment done, or you've got your assessment done, but there are no beds available to admit them to, because that then poses the risk that you're going to be breaching the patient's rights. There's a couple of points made in the Code of Practice about Section 136 not being used on a hospital ward. Quite right too, you don't need to use it because you've got Section 5 powers. But that it may be appropriate to bring the police back to the hospital for any non-inpatient area in order to use Section 136 there. So in the grounds of the hospital, in the car park, or even in A&E, the police can be called. But in my experience, it's vanishingly rare that the police will come out to an A&E department in order to exercise 136, because they'll view someone as already being in a safe place. Section 5, which I mentioned and which the code mentions, applies to any patient who's already been admitted. And under 5.2, a doctor or other approved clinician can hold the patient for up to 72 hours in order to consider whether the patient needs admission for assessment or treatment. And they can be compelled to stay, but they can't be compelled to receive treatment. And there's a corresponding power for mental health nurses or learning disability nurses to hold a patient for up to 6 hours in order to carry out the same assessments. But again, the patient cannot be compelled to receive treatment. They can be kept safe whilst the assessments are carried out. Now, I've included here at the end the case of Sese, which is a fairly old one, but it's a good case for highlighting the problems that are going to be faced in practice, particularly now that Section 136 only lasts for 24 hours. So in this case, police officers went out to Ms. Sese's home. They were satisfied that she needed looking after for her own benefit and for her child's benefit because of a mental disorder. They took her to the hospital whilst dropping off the child at the police station, and they purported to be acting under Section 5 of the Mental Capacity Act and taking the patient to the hospital's Section 136 suite. But crucially, they never invoked the Mental Health Act powers. When the police handed her over, the hospital staff mistakenly thought that Ms. Sese had been brought to them using Section 136. But when it later transpired that they weren't operating under the scope of the Mental Health Act, the 72-hour period that they had under that, they sought to argue that their actions were covered by common law and by the Mental Capacity Act because they've been acting in her best interests. And the court had a long look at all of this and went on to say, first off, that because there was a delay, that is the fault of the state authorities, the public authorities. There should be sufficient resources to carry out examinations in sufficient time. And in this case, Ms. Sese was held for in excess of 12 hours. And she wasn't held under the Mental Health Act because she wasn't brought in under 136. And the court said it was up to PCTs, as it then was, to arrange sufficient doctors and for the local authority to arrange sufficient AMPs. But it wasn't all bad news, because the judge went on to say that the Trust's policy of allowing people to be held up to 8 hours in the 136 suite would be lawful. So you can take up to 8 hours to decide whether or not to hold someone. But in this case, that had clearly been exceeded. The judge went on to say that whether or not someone has been falsely imprisoned will depend on the circumstances of the case. But in this instance, no evidence was produced to suggest why the Trust couldn't have considered the use of Section 4 under the Mental Health Act in order to admit her under the Mental Health Act on an emergency basis. So the Trust wasn't really able to argue that it didn't have sufficient resources to carry this out, because the court viewed that it had other means at its disposal to deal with the situation, namely admission under Section 4. The court said had the Trust been unable to use Section 4, then the Trust could have contacted the police to get them to come back. And that's where I allow myself a bit of a wry chuckle, because the police, having brought her to A&E, have dropped her off where they believe there is a safe place, it's vanishingly unlikely, in my view, that the police are going to send people back out again, only to invoke 136 to help you out of a hole with the timeline, and then to leave again. The judges concluded that the Mental Health Act provides a comprehensive code and that the common law principle of necessity doesn't apply. So what they're saying is if you're using the Mental Health Act framework, you are stuck with the Mental Health Act framework. You can't fill the gaps by trying to rely on the Mental Capacity Act and the Mental Health Act. And therefore, for this patient, her rights had been breached and she was entitled to a declaration that her human rights had been breached and damages. So what does that mean now, looking at this case some years later when you've only got a 24-hour time limit? My own view is that it can't hold anymore. I think you must be able to juggle the Mental Capacity Act with the Mental Health Act if the Act isn't available to you. So bearing in mind that the case said that the Mental Health Act is comprehensive and you can't use the Mental Capacity Act in the common law, I think that must now be wrong. The courts have accepted that there are alternate regimes, and the courts also now accepting that the two can be used in parallel. However, there are other powers that you can rely on, such as the Criminal Law Act, which enables you to act if you think someone's about to commit a criminal offence, so you can hold them for those purposes. Because if you don't, you've frankly got a really unpleasant choice, and that's letting someone go and they'll either harm themselves or harm other people, or you keep them beyond the 24-hour time limit and you risk a claim for damages. But my firm belief is that the court would far rather you kept the patient safe or others safe for a short period of time whilst trying to regularise the position than just letting them go. The situation in A&E or under section 136 is an awfully long way from the Essex-Boner case that we looked at, where the lady's rights have been breached for up to 6 months. If you're in any doubt, you can of course apply to the Court of Protection for an order, but how quickly do you want to do that? Because that involves, unfortunately, legal expense and possible further delays. The court can move really quickly, but if you think you're going to get a bed or an assessment done within the next few hours, are you really going to go rushing off to court at the 24-hour mark? I would suggest getting legal advice, but it may be the common sense answer is to actually wait, because the patient's absolutely where they need to be. I'm sorry, we've been running a little late. We'll now come on to the Q&As, and I can see we've got a good few there. Before we crack into those, apologies to those of you that ended up having to join us late. We had problems with our Zoom video conferencing provider, but I'm delighted to see that we've now got 90 participants. So we'll run on a little late. For those that have joined late but need to leave promptly on time, please don't worry, we'll be circulating the slides and a video of the webinar in which we'll be addressing the Q&A that come up after we finish for today. So we'll try and take all the Q&A now and we'll finish when we've got through those. So I'm going to take them in order of popularity. There have been 2 likes of Claire Diamond's question, and Charlotte, this is for you. Scope of parental responsibility regarding a decision and what can reasonably be expected of a parent. Is this for a child of that age and development and maturity, or is this a specific child with these characteristics and difficulties? So I think repackaging that, is it for any child, or do you have to take the child as you find them? Charlotte, you want to have a go at that?
Yeah, so I think well, without wanting to sound too generalist, it does depend on the case and the nature of the parent's involvement. It goes back to those questions as to what can reasonably be expected, it would be relevant for the child and factoring in their age and developmental maturity, certainly.
And just to sort of overlay Charlotte's comments, there was a case, I think 2 or 3 years ago, where the judge in question was actually quite brave, and he was looking at a specific scenario for a specific child, but he went on to say that those set of circumstances, I'm probably going to get the age bandings wrong, for a 9 or 10-year-old probably wouldn't amount to a deprivation of liberty because those restrictions would be normal for a child of that age with that presentation. But once they come on to be 11 or 12, you'd be having a good hard look at it, but it may still be lawful for the parents to consent to the deprivation of liberty. But once they get to 13 or 14, actually you'd start to worry and you'd think about going to court. But it is absolutely specific to the child and their presentation. And I think most importantly, the restrictions that are going to be imposed on them and the intensity of those. The next question we've got is from Sharon Conlon, which has received a couple of likes. What if the 136 has been charged, but the young person remains in the 136 suite as a place of safety because there's no safe place to discharge to? We currently use parental responsibility. Is this legal? That's a great question because that's right on the point of the Supreme Court's judgment. So by using the term young person, I'm taking it that you mean a 16 or 17-year-old. So as we heard from Charlotte's talk, parents cannot consent to the deprivation of liberty of a 16 or 17-year-old. However, if they are on board with it, then that is one point of challenge that you can get out of the way. And importantly as well, the Mental Capacity Act also requires you to consult with friends and family. And if the family are in agreement that the place of safety is in that 16 and 17-year-old's best interests, then actually there isn't anywhere else better for them to be. It does run the risk that someone later down the track may come along and say, you should have got authorization for this. And that would necessitate an application to the court at the current time, because it's the only way to do it, in order to legitimize that detention. But really, are you going to do that? If you've been in conversation with the commissioners and you know that a tier 4 bed's going to be ready tomorrow, is it worth really going to court to get 6 to 12 hours of coverage to get them from one place where everybody's agreed they need to be to the next place where we know they're going to need to be? I think the answer for that is no. It's more difficult if someone's been assessed under 136, the time has expired, and they've been deemed not to be admissible under the Act because their behaviours are as a result of anger or just simply challenging behaviour generally, and they need actually to go to a secure welfare placement, because then that's out of the gift of the CCG and the hospital. And if that's going to take any length of time, I would suggest you should seek an order, because actually why are they in a hospital setting at all if they don't have any clinical needs? The next question we've got is from Fiona Lynch. Do we have any guidance on how we should ensure that the rights of the child or young person being detained under the Mental Health Act should be shared with the young person and or their family? This is especially when a young person is with us on an acute ward for a significant period of time. Is there, for example, a requirement to read them their rights weekly? So I'll take that in the first instance, Charlotte. If you've got any thoughts, please do chip in. If they are being detained under the Mental Health Act, there's obviously a statutory obligation, and I think it's under section 132 off the top of my head, forgive me if I've got that wrong, which says who needs to be given what information. And it's absolutely the patient, and then it's also the patient's nearest relative, which if it's for a child would ordinarily be mum or dad. And those rights should be given when they're first sectioned. If they're not capable of understanding them at the time of section, then they should be given them again. And also, as Charlotte mentioned, I think during the course of her slides, the information has to be given to them in an accessible format as well. So there are statutory requirements to provide that information, not only to the patient, but also to the child. As to the frequency of that, I'm not sure, but I think regular sounds good. I would rather you did it more often than leaving it, to 6 monthly. But Charlotte, do you have any thoughts on that?
Nothing else to add, actually, Francis, other than that I think you're right with 132.
Right, thank you. Then turning to Dawn Crowther's query, currently we're looking at how we may respond more swiftly to crisis situations for children and young people. The Code of Practice has slightly different wording around requirements if professionals involved in the Mental Health Act assessment are not CAMHS assessments or approved Mental Health Act professionals with relevant expertise. The code, I'm assuming that's a reference to, talks about professionals who do have relevant expertise, and section 14 section 1649 says we should discuss with appropriately qualified persons, which I presume means a CAMS consultant or an AMP. Can you clarify whether a clinician would mean a CAMS crisis team, for instance, or should this still be taken as a CAMS consultant or AMP with expertise? The short answer is I'm not sure without looking at the detail of the Act, but I think if you're in an emergency situation, I think take your expert in inverted commas where you can find them. If you've got someone with appropriate professional qualifications, but who might not be an approved clinician or a qualified AMP, then that's going to have to be good enough in a crisis. If you can then get someone with the appropriate qualifications thereafter to weigh in and have a look, so much the better. But Dawn, I'm afraid I don't know the answer to that off the top of my head, so I will come back to you on that separately once I've had a look at it and given it a bit more thought. And we've got Adrian McCorkle's query. Under 136, is the requirement for the patient to go to the nearest place of safety? For example, the nearest, if it's full, can the patient be taken to another one which does have space? Absolutely, yes, it can. And also, you can be taken from one place of safety to another. So it's not just a question of turning up at the nearest one and being told there's no room at the inn and having to go to the next one. Someone actually can go to a police station, for example, in the first instance because of their continuing criminal behaviour. But once they've settled, the police may deem it more appropriate for them to go to a health base of safety and then to be moved and transferred across. So those moves can take place. It doesn't have to automatically be the nearest one. Charlotte, this next one I think is for you from Claire Diamond. When the local authority have a care order, is there any difference in using the scope of parental control? Do you want to have a crack at that one?
Yeah, so essentially if the local authority have a care order, they have probably been awarded or been given parental responsibility for that child. So you'll certainly need to have discussions with them about the scope of their decision-making ability, and they may feel that they are unable to make certain decisions without further assistance, either from another parent, if the parent retains some sort of parental responsibility, they have shared with parental responsibility, or even the court. So I would certainly still ask those questions of the local authority in that position.
Thank you. Then we've got Judy Preston's question. What is your advice about a young person aged 16 or 17 who attends the emergency department who doesn't want their parents called? Charlotte, I'll let you tackle that as well in the first instance.
Okay, yeah. So you'll have to have a discussion with them. What sort of treatment is required? Do their parents need to be called? And are they competent to make that decision? Well, they're presumed to have capacity if they're between 16 and 17 years old. So it would require a discussion with them and the consideration of the benefits and disbenefits and respecting their right to confidentiality in the first instance. So in short, there's no right or wrong answer on each occasion. There's no blanket right or wrong answer. You'll need to consider it on a case-by-case basis.
I think the starting point for that consideration is, first of all, whether the person's got capacity. Obviously, if the 16 or 17-year-old does have capacity, then actually they can make decisions about their own care and treatment, and they can make decisions under the GDPR to bring sort of information for a moment about who gets what information about them.
Precisely.
It may not be appropriate. Last but not least, Adrian McCorkle, who I think got the first question in at 217, and it's one for me. Under the new Section 4B of the Mental Capacity Act, would Adrian, as a paramedic in a dwelling with the patient legally, so not using Section 1386, be able to use the new Section 4B to remove a patient who lacks capacity and is suffering a mental health crisis to an emergency department for a mental health assessment when we're unable to get an AMP to undertake a Mental Health Act assessment, and we believe it's not safe to leave the patient without the assessment taking place? The short answer is, it's my personal view, is yes, which is nice and easy. The more complicated answer is, I'm not sure, and it will depend. We are hoping to get the Code of Practice and the regulations next year, which will make it very clear the sorts of situations in which 4B can be exercised. But taking your example, if this is somebody who lacks capacity to make a decision and is a risk to themselves at home, then why wouldn't you move them in their best interests? The deprivation of liberty applies as much to keeping them in their home as a place of safety as to the conveyance, taking them somewhere else. Ordinarily, we don't talk about requiring an authorization for deprivation of liberty to transfer someone. But if it is going to be a long transfer, then actually you would need an authorization for that transfer. But on the wording of the Act, as I understand it at the moment, that scenario would be lawful, which does rather call into question when you would use 4B as opposed to when you would use section 135 and 136 of the Mental Health Act. And I'm hopeful that the code will break that down, because what they'll be very keen to ensure is that patients' rights aren't abrogated by using the Mental Capacity Act to sidestep section 136. But clearly, in the example you've given, if there's no AMP available and they're going to be a danger to themselves at home, then yeah, we should get on and get them to that place of safety by hook or by crook, would be my own personal view. Now, I think we've had another question pop in, but I'm struggling to see where it has gone, unless I'm mistaken. No, I think that is all the questions that we have had. Grand. Well, thank you very much, everybody, for attending. My apologies again for the difficulties we had with Zoom, unfortunately, meaning the link that we sent not working. If anyone would like to make contact with Charlotte and I directly, our contact details are on the final slide, which we'll send through. And we're very happy to pick those up separately. The video of this will be circulated, as will our responses to the questions. My last final plea would be to remind you about the feedback form that will also be coming out. If you could fill that in, that would be great, because it'll help us tailor similar presentations in the future, and also to give us a heads up about what you'd like to hear about in the future. I have just seen, as I've made my closing remarks, 2 more questions come zooming in, but in fairness to those of you who need to get on, we'll answer those via email. So thank you very much for your attendance.